This video dives into a tense courtroom hearing where a dispute over child support takes center stage. Miss Carpenter seeks a modification of the existing order, arguing that her ex-husband, Mr. Birch, is earning far more than he claims due to his involvement in multiple businesses. She believes his financial situation has significantly improved and that the current support amount no longer reflects his true income. As the hearing unfolds, it becomes clear that much of her argument relies on unverified sources such as online searches, LinkedIn profiles, and even information from their teenage child. On the other hand, Mr. Birch maintains that his annual salary is $90,000 and insists that, despite having ownership stakes in businesses, he does not receive any additional income or dividends from them. The judge carefully examines both sides, focusing heavily on the lack of concrete financial evidence presented. Without documented proof of increased income, the court ultimately denies the request for modification, keeping the original child support order unchanged. The case highlights the importance of solid evidence in legal disputes and the challenges of proving hidden income in court.
You know for a fact he does own East Texas Truck Center, and he does have a business in Nacogdoches and a business in Baytown.
Okay. Is the East Texas Truck Center, is that his main source of income?
Yes.
Okay. And you said that he's the owner of that business?
Yes, that's correct.
Do you have any idea what kind of income that business generates?
I would guess probably 3 to 5 million. I did submit, and I'm not sure if you received it yesterday. I did get online and look at the appraisal districts for his property values. Did you receive that?
I did receive it.
Okay. So as far as his property values, which like I said, I can't state as to far as his revenue because it is an LLC and the financial information is not available. But I will say, like, as far as property owned in Baytown, per the appraisal district, it's 1.1 million. In Nacogdoches, he owns 5 properties, 3 of which were just acquired in December 15th, 2021.
Ms. Carpenter, stop.
Yes.
Ms. Simone, I need you to ask questions.
Yes, sir.
Thank you.
Sorry.
Okay, you stated that he owns other businesses. Do you know what the businesses are? Or what the name of the businesses are?
I can, if you look at his LinkedIn accounts.
I don't have that available. Sorry.
Okay, I'm pulling it up right now. I'll look it up on my computer. It's a lot faster internet.
So, Ms. Carpenter, this information that you're about to give me is something that you're looking up from somewhere else?
The businesses owned is just from his LinkedIn account president.
You don't know this information personally. This is just information that you're searching on the internet for.
And also my 14-year-old has told me as well.
I will call Mr. Birch. Mr. Birch, would you state your full name for the court, please?
Joshua Paul Birch.
Okay. And you're the father of Aubrey and Adeline Birch?
That is correct.
Okay. And are you currently covering the children on your health insurance?
Yes, ma'am, I am.
Okay. And can you give me the cost of that?
$315.97 per month per child through Blue Cross Blue Shield.
Okay.
So $631.94.
All right. And where do you currently work?
East Texas Truck Center.
Okay. And are you the owner of that business?
I'm a minority owner in that business.
Okay. Are you paid a salary?
I am, yes, ma'am.
Okay. And what is that salary?
It's $90,000 a year.
Okay. Do you own any other businesses besides the East Texas Trucking Center?
So I'm a minority owner in East Texas Truck Center, Inc.,
okay.
which is not a LLC, and I'm a minority owner in East Texas Truck Center, Baytown, LLC. I'm a minority owner in Keystone Financial, LLC, and I'm a majority owner in Cornerstone, LLC.
Do you receive any other type of revenue from East Texas Truck Center? besides your salary?
No, ma'am. Unless there's a dividend given, but we haven't given dividends.
Okay. Do you make any income from the Keystone Financial?
No, ma'am. There's no salaries or dividends given from that either. It's a startup company.
And do you make any income from Cornerstone Financial?
No, ma'am. Same thing. It was also established last year.
Okay. And you said Keystone, when was that established?
Keystone was actually established in 2000. I thought you said Keystone the first time. My apologies.
Yeah, I did. I'm sorry.
Keystone was established in 2018.
Okay.
I'm a minority there as well.
And you have not received any income from Keystone to the state?
No, ma'am.
Okay.
Leads me to believe that there's been a change. So the state not meeting its burden is therefore the motion is denied. If any party is dissatisfied, no, that's okay. I don't need to hear anything. If
I'm not understanding what's denied, sir. The new order or the old order?
I'm denying the state's. There's no new order, Mr. Birch.
Yes, sir.
You and Ms. Carpenter and the state were not able to come to an agreement, and so
Yes, sir.
a lawsuit was filed before me to see if the child support needs to be adjusted. The laws in this state are very simple. The state or whoever it is that's moving, asking me to adjust the child support has to prove what your old income was, where it came from, and the circumstances behind it, and then compare it to the new information that you have. And I find that the state has completely and utterly failed to do that. They haven't proven anything to me. They've thrown out some stuff, but nothing with any concrete or significant basis. And therefore, I'm denying the motion because they haven't met their burden of proof. They haven't proven to me that there's been any kind of a change. So any party has the right to appeal my decision. Your appeal must be filed with the Orange County District Clerk's Office. It has to be filed in the next 3 business days. And you have to make sure that you specify in your appeal what part of my ruling you disagree with. And you're also responsible for making sure that a copy of that written appeal is sent. Let me finish, Mr. Birch. And you're also responsible for sending a copy of that written appeal to all the other non-appealing parties. All right. Now, Mr. Birch, what were you going to say?
If her medical is obviously cheaper than what I'm providing at $631 per kid, and she's at $291 per kid, is there a way that instead of me paying Blue Cross Blue Shield the $631, that I could pay her the $291 for the medical?
If y'all can sit down with the AG's office and come up with another agreement, you have my permission to do so, but I'm denying this motion. So y'all have to start over in regards to that issue, okay?
Yes, sir.
Yes, sir.
Anything else? And that's a very good question, Mr. Birch, and I hope that you and Ms. Carpenter are able to sit down and get that hammered out to make sure that we've got good medical insurance and good for the both of you. So it's good for you financially as well as from your situation that you're in regard to the 2 children, okay?
Yeah.
Ms. Carpenter, do you have any questions?
No, I mean, the priority was the medical.
All right.
I mean, that was my major point.
As the hearing concludes, the courtroom atmosphere remains tense, but the judge delivers a firm and decisive ruling. Despite the strong accusations raised, the lack of concrete financial evidence ultimately weakens the case for modifying the child support order. The court emphasizes that assumptions, online information, and second-hand claims cannot replace verified documentation when it comes to legal decisions. Mr. Birch's testimony about his income stands unchallenged by any solid proof, leading the judge to deny the request for an increase in payments. The original child support order remains in effect, reinforcing the idea that any change in financial responsibility must be backed by clear and reliable evidence. In the end, the judge encourages both parties to focus less on conflict and more on cooperation, especially when it comes to their child's well-being. The case serves as a strong reminder that in legal matters, preparation and proof are everything, and without them, even serious claims may not hold up in court.